Shall we begin the meeting?
Please.
Yes.
Mr. Barso, will you please read the agenda?
Yeah, the first item is call to order, which you just did. Second item is the approval of minutes and support documents from the prior meeting. I sent that out a few days ago, and I know I received a response from Conray. I don't know if, Mr. Thoreau, you've had a chance to review it.
I did.
And are we all good with that?
We're good.
Okay.
Well,
I move we approve the minutes.
I second it.
all in favor?
Aye.
Aye.
The second item is an open meeting law complaint, discuss and commission response from the Lakemont Dock Committee, received April 27th, 2026.
Yes, with that, can I have permission to share my screen, please?
Yes.
And by the way, before you do that, Mr. Barstow, and Mr. Please close out any emails that you have or any open tabs.
Okay, so let's see.
I mean, other than obviously the Zoom meeting.
Yeah.
Mine are all closed. The only thing that's open is Zoom.
So, I think they somehow it looks a little different. I'm trying to see the button to now enable you to share this. I see share, and it comes up looking different than it used to. I see share settings, host tools
Oh,
for
hold on a
sharing.
minute. Hold on a minute. It looks like I have permission.
Oh, okay. There you go.
Can you approve it?
I did.
Okay, can you all see my screen?
Now we can. Yes. Response to open meeting law complaints.
Okay, let me just reduce this because I've got you guys up on my screen. Okay, so look, this is first of all, I want to acknowledge that we received the complaint. Secondly, just as a matter of the minutes, have either one of you received this presentation from me?
I have not.
No. Assuming this is different from the one you presented at the last meeting.
Yes, this is completely different.
I have not seen it.
Okay, so let's go ahead and get started. For some reason, this toolbar just will not be removed from my screen. But anyway, so first of all, I want to make an opening statement. So as I mentioned at the start of this meeting, we're here to, simply address this open meeting law complaint that was received. This was our second specifically related to Basin 4. So with that in mind, look, I think we as a committee need to recognize that the open meeting law is, essentially a fundamental safeguard of public accountability. So any resident who believes a public body, especially ours, has fallen short of its obligation has the right to say so. So I want to make sure that for the record, and nobody on the call thinks that we begrudge people for putting us through this exercise. One of the things that we've really tried to do as a Lake Boon Commission is be as candid as we can be and as transparent as we can be. Obviously, people have opinions and agreements or disagreements on what should happen on the lake. So we're open to challenge those. When you're talking about the open meeting law, you're talking about how business is conducted. So we reviewed every communication cited in the complaints. We handled Sarah Hagan's complaint at the last meeting. This one is from Richard Weiss of the Lakemont Dock Committee. So we're going to go through each one of those, and anywhere that we feel as a committee that we can do better, we're obligated to say so. So one of the things I want to make sure that we do as a committee is take these things,
This is it.
I'm not gonna, Dan, Mr. Barso, I'm not gonna have people talking.
Right. I just muted Mr. Koenig.
Okay, thank you. So we're gonna go through this, and here's what you're gonna see is my work. It's my exclusive work. Mr. Barstow and Mr. Worf, you haven't seen this.
No.
So this is just my work. But ultimately, what we respond to the state has to be a collective judgment, meaning that throughout this presentation, Mr. Barso, please take notes of any disagreement or any position that's taken contrary to what I'm suggesting. The purpose of this presentation is just to, drive dialogue. It's not to drive conclusions. And we all don't have to agree. We don't have to be one mind. Disagreement is welcome. So Mr. Wharf and Mr. Barstow, if you don't agree with anything I've said, or you don't agree with any of this analysis, please challenge it. Obviously, we couldn't circulate this in advance and, communicate it in advance. So it's the first time that you're seeing it. So if you don't agree with it, let's go on the record that you don't agree. Okay?
Thank you.
Make sense?
Yeah.
Yes.
Okay. So an allegation was filed against the Lake Boon Commission. This was the second. The complaint alleges that we engaged in serial private deliberation. I just want to make sure that that word is highlighted. The Lake Boon Commission engaged in serial private deliberation among a quorum from February 19th through March 18th and pre-decided the adoption of rule, I think that's 7B, Mr. Barstow, the prohibition of new docks and moorings in Basinville outside of any properly noticed public meeting. I'm going to pause there just on the complaint. Serial private deliberation among a quorum for more than a month and pre-decided the adoption of the rule outside of any properly noticed public meeting. Here's what I found. And again, you guys please feel free. The facts are completely opposite of what the allegation is. We had 2 properly noticed public meetings. We took live public comment from the Lakemont representatives themselves, and we adopted the rule only after the second meeting and only after experts testified and on the record bylaw language was negotiated. That's my conclusion, and I'm going to go through the next 30 pages to explain how I got to that conclusion. But out of the gate, based upon what you all have read in the complaint, does anybody believe on its face that this is accurate?
No.
Mr. Wharf?
You're asking me if the complaint is accurate, not if your response is accurate.
No, I'm asking you if the facts as you're aware of them are accurate.
Oh, yes, they are.
Oh, wait. I'm sorry. I
No,
need to understand
are my
the nature
facts
of your-
accurate? Are my facts accurate?
the way you stated your comments is accurate, Mr. Terrell.
Thank you.
Yeah, Mr. Terrell, I agree. Basically, it's the bottom line on this slide. We held 2 properly noticed public meetings, etc.
Exactly.
It is accurate. And the rule numbers, was that 7C or is that?
I think the rule is 7B, but I'm just lifting off the complaint.
Okay.
So we have 2 separate complaints, but one shared misunderstanding. Mr. Weiss, the Lakemont dock community, they're asking the Attorney General office to rescind a duly adopted bylaw, force a commissioner, you, Mr. Barstow, to choose between civic offices, which are the Lake Boon Commission, and the LBA. Just to be sure that people on the record understand this, the Lake Boon Association is not an official organization. It's a social organization. It's not an office, and it doesn't have rulemaking authority. And further, Mr. Weiss is asking that we publicly apologize. Ms. Hagan, which we responded to already, this has already been discussed. She also is asking for a repeal of the bylaw and replace it with solutions that actually affect the things that they claim are wrong with the lake. So just an understanding about the open meeting laws in Massachusetts, neither remedy that they're seeking exists under the open meeting law. The Attorney General's office cannot grant either one of these requests, not because the commission opposes it, because the statute itself doesn't allow it. So let's go through what it does allow. The open meeting law governs how public bodies deliberate. The concern is that there are meetings that take place that don't have the public involvement, are not properly noticed, and are not supported with minutes. They don't govern what those commissions decide. Disgruntled homeowners in disagreement with the substance of a public body's decision is not an open meeting law violation. The complaints are challenging the substance of the rule, what should be regulated, whether or not the dock prohibition is the right policy choice, whether other solutions would work better, whether a commissioner can participate in a social club, and whether the commissioner was wrong on the merits. None of those are within the purview of the open meeting law. What the open meeting law governs is whether or not we noticed the meetings properly, whether or not we had deliberation in open session, whether minutes were created, and whether prohibited quorum communications outside meetings exchange opinions on a pending matter. In my opinion, the meetings were properly noticed. We had 2 of them. We had deliberation in open session, and we invited the towns and the community to participate. We actually had open comments available in both meetings. We have minutes and video of the meetings, and we will go through the communication, all of which is allowed under the open meeting law. So both of the complaints that we receive are trying to attack the merits or substance of the rule. They're not, although they're disguising it as an open meeting law violation, the remedies that they're asking for aren't even remedies under the Open Meeting Law Violation Act. So let's back up. I have this toolbar, Dan, on my Mr. Barstow.
We don't see a toolbar.
Okay, I see this. Okay. So let me ground everybody in making sure that we understand this. A dock in any body of water is not a right. It's a licensed privilege. There's no right for any individual in Massachusetts to own a dock or have a dock on a public waterway. So the open meeting law challenge and the remedy requested is to grant a right that doesn't even exist in the state. In order to have a dock on the lake, you need to go through Section 91, you need to go through the town, and you need to not violate any of the bylaws of the lake or water body that you want to put the dock on. So there's no right that's been violated here. And so the Supreme Court has answered this unanimously multiple times. It's black letter law in Massachusetts. Private use of public trust waters requires a license, and that license can be conditioned, denied, or restricted. A dock is a conditional privilege. It's not a right. So anybody asserting that their right was removed is categorically wrong. That's just a background for everybody listening to the call on what a dock constitutes. It's a privilege. So the Attorney General's office cannot specify or order a public body to reverse a policy choice or repeal a duly adopted bylaw based upon substantive grounds. So let's go through each one of them. Even if the Attorney General office was to repeal or rescind the Rule 7B, all it would do is require us to have another meeting, likely with the same outcome. Although it might not be the same outcome, all they could ask us to do is have a meeting again. The Attorney General has no authority to order a public body to adopt a different substantive policy. The Lake Boon Commission is authorized under the state to regulate the use of the lake. It is within that regulatory framework that we can limit the docks and the placement on the lake. For example, we could limit somebody from building a dock that stretches entirely across the lake. There's no conflict of interest as alleged. Mr. Barstow, it was alleged that because you participate in the Lake Boon Association, you can't be on the Lake Boon Commission. The Lake Boon Association has no governing authority on the lake. Unless we decide as a committee that you're compromised with the Lake Boon Association, it's not a regulatory body, it's a social club. And then the demand that the Attorney General office order us or compel us to apologize to the public isn't even a remedy. It's not a remedy that the AGO can even grant. So with that, I'm going to stop here. The only one that we can question is Mr. Barstow, whether or not you believe there's a conflict between your participation in the Lake Boon Association and your participation on the Lake Boon Commission.
No, there's no conflict.
Okay. Does the Lake Boon, Mr. Worf, you've been on the commission for years. Does the Lake Boon Association make laws or rules governing the lake?
Absolutely not.
Okay.
The Lake Boon Association has changed the name over the years, reflecting the fact they are simply a social organization. It's homeowners in the lake to get together. That's all it is.
Okay.
And Conray, if you could speak a little louder or get closer to the microphone, it would help.
That better?
Yeah, it's a little bit better. Let's hear if you have to talk again.
Okay.
Okay. I'm going to pause there. Because I'm going to keep going unless you guys stop me. So, Mr. Barstow, is there anything that you want to comment or any questions you have so far?
No, only I appreciate the depth that you've analyzed this and referred to law precedent and so on.
Mr. Warford, do you have any questions or comments?
No, kind of the same comment Mr. Barstow had. Having been on the commission for 25 odd years, this is absolutely correct.
Okay, let's keep going because Mr. Barstow, we're going to go really deep because we want to make sure that these complaints are properly addressed. So when somebody files a complaint, they must allege specific facts. The Attorney General's office, especially with the open meeting law, is not an investigatory body. They don't go out and collect an investigation. They rely upon the committee itself to self-police. And so the original complaint that we received was conditional. It said there may be a violation. What she had observed during the meeting was a window that you had open, Mr. Barstow. I'm hearing paper shuffling.
I muted the person.
Okay, thank you. And then the second open meeting law violation treated document distribution as deliberation, treated agenda setting and meeting prep as deliberation, recast compliance behavior, the open meeting law trap, we'll discuss that in a minute, address comments to me as evidence of intent to violate. It's actually the complete opposite of the intent to violate, which I'll explain in a minute. They treated Lake Boon Association correspondence by a commissioner acting in his LBA role as if it were LBC business. We already talked about this. The LBA is a voluntary social organization and has no regulatory authority on the lake, and quotes context strip fragments to imply predetermined outcomes. And I'm going to go through each single exhibit and tell you why that routine inter-meeting administrative coordination is not only permissible, it's encouraged, because you can't function as a public body if the members of that public body can't communicate. And that's been established universally in every state in this union. So timeliness is one thing that we got to talk about, because a violation that occurs during an open session of a meeting is reasonably discoverable on the date of the meeting, which means that if you are witnessing an open meeting and you believe that there has been something observed that violates that, that's what triggers the actual complaint date. So I won't go through each one of these, but Ms. Hagan's response has been dealt with in the prior meeting. And the Lakemont Dock Committee alleges targeting what occurred at those notice meetings. The position paper, the public comment approach, the vote, those are all time barred, because those were things that were discussed at the meeting. So let's continue to go forward with this. So they use the wrong doctrine for serial deliberation. Serial deliberation is when you have a large public body, usually consisting of more than 5 members, where they're sharing a chain of communication. The Lake Boon Commission is 3 members. So by definition, any 2 members that talk is by definition a quorum, simply because we have 3 members of the committee. So the doctrine requires a chain of one-to-one communications, typically beyond 3 people. 3 members means that there's really no serial change. And so it's when I said direct comments to me, it's to prevent that exact chain to occur. So opinion exchange on the merits is not serial deliberation. So the initial complaint, not the initial complaint, but the subsequent complaint of the open meeting violation doesn't really comprehend that communication between 2 people related to the agenda or the items to be presented at the meeting does not represent serial communication or deliberation. So what defines it? Anything that we do is going to be a quorum because by definition, there's only 3 of us. And then it's going to be a substantive debate or discussion on the merits of the policy to be discussed. That's what it requires. If either element is missing, it's not deliberation, meaning like sharing of communication materials, posting agenda. Disagreeing with the resulting rule is not by itself evidence of a violation. In order to violate the open meeting law, it must show intent to deceive or to remove deliberation from the public view. Deliberation means an unauthorized or impermissible oral written communication through any medium, including electronic, email, between or among a quorum of the public body or any public business within its jurisdiction. It means unauthorized or impermissible. That should say impermissible. Mr. Barstow, I'll correct that. So what is not a deliberation? And we went through this the last time. Scheduling, agenda preparation, distribution of reports and factual materials, communication with municipal staff and outside agencies, or communication with members of the public. Those are not deliberations. Now, we're going to go through each complaint and we'll decide if we violated the open meeting law or if there's areas for us to improve. Okay, so with respect to the open meeting law complaint itself, let's just waive the fact that they filed it. It was distributed. We're reviewing it within 14 days, and we're going to issue a response. Just like we did in the last meeting, Mr. Barstow and Mr. Worf, I would like at this time to ask if I'm going to be empowered to issue the response on the behalf of the commission.
If we eventually agree with everything you said, you will be empowered. That's what I would
I
vote.
believe we have to do a motion and vote to make that happen, though.
Yeah, we'll table that at the end.
Okay.
Okay. So now let's talk about facts. Can you please mute whoever's
Yeah, please mute me.
Thank you.
Just
Okay.
footnote, this is not open for public comment. This is not a hearing. This is a LBC meeting. Everybody's welcome to listen, but not to comment.
Okay, so I just want to make sure these facts are correct. Did we have a public meeting on March 4th?
Yes.
Yeah,
Was it properly noticed?
yeah.
Yes.
Meaning like did both towns get noticed? Did we take a vote on March 4th?
No.
No, we postponed it, but to go back to the proper notice, it was noticed not just in Hudson and Stowe, but it was also noticed through the David Gray email distribution of members of the lake. So we went beyond the requirements to publicly notice it.
Is there, Mr. Worf, you've been on the commission for a while, is there a requirement in the state of Massachusetts to send the agenda and the meeting link out through a social organization like the Lake Boon Association?
No, there is not. But
Mr. Barstow, is there any obligation for us to?
No, there's no
go beyond?
obligation. We did this to make sure everybody was aware.
Okay, so if we did not take a vote in the public meeting, did we pre-decide what the outcome of that meeting was going to be?
No.
no.
So would it seem unusual that a predetermined meeting would would not then in the first meeting hold a vote?
Yeah.
We wanted to make sure we had public input. We saw that we should have a second meeting to make sure that was possible.
Okay,
I'm gonna comment the same, that at first meeting, we learned facts that we did not know. And we then had, that's why we decided to have a second meeting to make sure that we had all things covered. Everybody had the chance to talk to us.
Did the Lakemont members of the Lakemont community, were they prohibited from speaking at the meeting?
No,
No.
And they raised concerns that maybe the meeting was rushed, did they not?
Yeah, they especially requested, I'm trying to remember if it was the first or the second meeting, but they especially requested time for that meeting, and we made sure that they did have that time.
So in between the meetings, did we communicated on making sure that the second meeting had all of the questions that people raised in the first one that they were going to be addressed?
We wanted to make sure we addressed those.
Okay. And we invited additional people to participate.
Yes.
Was the Lakemont community representative given extra time?
Yes.
yeah,
Did we,
You made sure that you did not cut that short in any way.
did I also say that in addition to the chairman of the Lakemont dock community, their representative, anybody else in addition to that would be allowed to speak?
Yes.
Mr. Wharf,
yes, you did.
did I at any time tell somebody they could not speak at the meeting or not offer facts?
No.
No, and not only did you not, none of us did.
Okay, so then we held a second meeting. Was that meeting properly noticed?
Yes.
Did we have 5 people that we would classify as either involved or experts testify, including the towns?
Yes.
Were there more than 35 people on that call?
Yes.
Your recollection?
I'd have to go with Mr. Barstow's on that because I think so.
Okay, did we negotiate the bylaw in real time?
We sure did.
Yeah, we did.
So if again, just checking my facts, if we had predetermined what the bylaw was going to say, and if we had predetermined the outcome of that meeting, was it necessary then to negotiate the language live?
Not if it was predetermined.
It was not predetermined. It's a complicated issue. We needed this time in public forum to hear the experts, to hear the people involved, so that we could, in public, deliberate this issue. That's why we did this.
When did you make your decision, Mr. Barstow?
I would say minutes before the vote.
Mr. Wharf, when did you make your decision?
During the meeting, based on the facts that were presented.
And I will echo the same. I literally did not make my decision until right at the time that we were voting. So let's keep going. So Mr. Barstow, your contemporaneous comments that are reflected in the minutes, I'd like to speak from the heart. This has been really tough process to think through. Obviously that reflects that you were still thinking through it, not a pre-formed position. Is that correct?
Absolutely.
Mr. Wharf, your statement.
It's correct, and I still stand by it.
And me, I went through the questions with you guys to just on the way I thought about it, and I had not given those questions to you in advance. Is that correct?
That's correct.
Okay. All right. So let's go through each exhibit and talk about it honestly. Look, we either have communications that are defensible or not. And if we have communications that are not defensible, then as I mentioned at the outset of the meeting, we have an affirmative obligation, a mandatory obligation to be on record if you disagree. We all agree with that?
Yes.
I have no problem with you two outvoting me at all. If you don't agree with me, we can change it. This is a draft. This is not a final document. So anything that needs to change, Mr. Barstow, I know you got an eye for this. Just let me know. Okay. All right, let's go through Exhibit A. I'm not putting the emails, I'm just putting the content of the emails. You all have the emails from the complaint if you'd like to refer to them. Mr. Barstow, this came up before. You're also on the Lake Boon Association, meaning that social club. And so you were asking a question of Ms. Hellenick, is that correct?
Yes.
Okay, so there's no quorum when you reach out in your social capacity on the Lake Boone Association and ask a question of the town. That's
Okay,
it's
right, but could you also clarify if I were to communicate in my role with the Lake Boone Commission with Miss Helenek, that's an allowable communication, correct?
it's allowable both as LBA and LBC because we're not involved. So you can reach out to either town anytime you want. Mr. Worf, you can reach out to either town anytime you want. The only time that it becomes a problem is if it's a quorum and, or a serial communication where you communicate with her, then it comes to me and we're deliberating on something. But, Mr. Barstow, I would probably recommend that, you be more conscious of how you're communicating to them because, as an
Sure.
individual, you sort of have to be aware that somebody could be misinterpreting your communications.
Yeah, and to be clear here, the Lake Boone Association, when we got the grant from the state, and by the way, we've had communications about these issues of the health of the lake and the dock for at least a half a dozen years, public communications about this, and the when we got the grant, we had the Lake Boone Association implement the grant, the Lake Boone Commission received it, and so on. But the representing Lake Boone Association was in association with that grant and the Lake Boone Association's concerns about the health of the lake. The Lake Boone Commission, because we didn't deliberate what communications LBA could have with the Hudson or Stowe. That was, it was done through the Lake Boone Association.
So probably just here, just be more, aware that people will
Sure.
get your emails because,
No, I see that point. I mean, the communications were all aboard and legitimate, but I see how that need to be clear about that.
yeah, my conclusion is there's no quorum. It's perfectly reasonable for you as an individual to reach out to either town. I don't see any violation. So on Exhibit A, that's my conclusion. Do either one of you disagree?
Do not disagree.
I agree.
I agree with your conclusion.
Okay.
And
Exhibit, I and J, we communicated, Lakemont Dock Committee requested speaking time. We allowed it. We've already discussed this. Mr. Barstow, you forwarded it to me and to Mr. Worf. This was about whether or not they could be on the agenda. Worf said, interesting, they have a dock committee, to which I responded, that won't last long. A dock committee formed for the purposes of a meeting is a dock committee formed for the purposes of a meeting. It's my opinion that if you form a special committee for one meeting, by definition, that won't last long. That was my opinion. It's not administrative in nature and it's not deliberative in nature. So there's no opinion exchange. It was my opinion that a committee formed for one specific meeting, by definition, isn't an ongoing committee. That's an observation. Does anybody disagree with me?
No, I agree.
Mr. Worf?
I agree.
In any case, we fully allowed them to speak.
We 100%. They could speak as long as they want. Every single member of the Lakemont community could have talked if they wanted to. All right, Exhibit B, agenda confirmation, a multi-day exchange about scheduling the March 4th public meeting, confirming the agenda format, proposed agenda, rule text to be proposed, the scheduling. Scheduling and agenda preparation are completely excluded from the open meeting. I mean, I don't even know where to start. You cannot function as any public body if you're not allowed to communicate what the agenda is. And I made a comment, we have to figure out what that means, identifies an open question for the meeting. It's not an opinion. It's that if we go to a meeting, we have to determine in the meeting what that rule means or what that potential language means. That, by definition, is saying in the meeting, we need to figure these things out. So scheduling and agenda are expressly excluded from the definition of deliberation. We don't even need to discuss this one. Mr. Barstow, Mr. Worf, do you disagree? You've seen the email.
Yeah, I completely agree. It would be impossible to function without that.
Yeah, I agree. It's impossible to function. And the only thing we're not talking about here is research.
Yeah, we're getting to that.
Okay.
So Exhibit D, we'll talk about that. So the dialogue of what constitutes a wetland, what constitutes wildlife. The fact that there's protected wildlife in Basin 4 signaling an automatic trigger is a factual regulatory research expression. That's what that is. Meaning, like, if there are beavers in the area, this will trigger a discussion. That's expressly excluded because it's factual research. The merits of the framework that we were discussing in open session is completely legitimate. Anybody who wants to do public research on beavers is allowed to do so. Anybody that wants to do public investigation on what constitutes a wetland or what constitutes a great pond is allowed to do so. There's no violation when you're talking about research that's publicly available that triggers something that we should consider in a meeting. That was my conclusion of that email. Mr. Barstow or Mr. Worf?
I agree.
I said that we have almost an obligation to distribute research so people can review it before a meeting so we can then deliberate on it.
Mr. Worf, precisely. If we have access to research materials or wetlands guidelines or guidelines related to state available public research, we're obligated to share it. It's the complete opposite of an open meeting law violation. Do either one of you disagree?
I agree.
I agree.
Forwarded research from an outside attorney on the enforceability of restrictive covenants. We have no obligation to engage in debate. We can listen to public comments and just say thanks. The chair's observation describe compliant procedures. Under the open meeting law in the state of Massachusetts, a commission does not have an obligation to debate individual members of the public. We can listen to the public comments and we can say thank you and move on. Public meetings that devolve into debate of individual committee members and individual members of the public, they lose complete control over the meeting, as we've seen in the past. Documenting compliance with the open meeting law requirement is not a violation. Anytime that I send or any of us send communication among each other saying how we should handle something that forces us into compliance with existing regulations is not a violation of the open meeting law. In fact, it's the exact opposite. It's trying to drive compliance into the meeting. That was my reading of that email. Mr. Barstow or Mr. Worf, do you agree or disagree?
Agree.
Historically, I've been on the commission for 25 years, and this is what we have to do all the time. The state does something, we have to look at it and figure out how it impacts us. First, you distribute it as research, and then you debate it.
Again, the emails that were cited in the complaint are our attempts to be compliant with the open meeting law and to control the agenda, not deliberate the prohibition.
I would agree.
This is on 3/5/26. After confirming with Mr. Barstow that prose language did not substantially change from the first meeting, the chair wrote we should have a meeting that by invitation we only ask LBA and Stowe and Hudson Conferee. We're talking about the agenda. Now, would it be prudent to list every possible interested or disinterested party, which could number in the hundreds, that we go through each one as a committee? Did I ever say to anybody that we should develop a comprehensive list or a list that, this email says that it's the towns of Stowe and Hudson conservation committees. That means like not the Stowe Select Board, not the Hudson Planning Commission, not the Stowe Tax Board, not the Hudson Chief of Police. This is related to the final language and approval of the agenda. That's what it's related to, which is completely excluded from open meeting law violation requirements. We were talking about the agenda flow, not the vote of the actual prohibition of the docs. That was my interpretation of those emails.
I would have the same interpretation, Mr. Worf.
Yes, and in fact, we did include other people, the science committee, for example.
Right. So this was not an attempt to predetermine whether or not we should vote on the doc. It was to determine who was speaking at the meeting. Is that correct? Meaning like Hudson and Stowe both have lots of committees, they have lots of commissions, and they have lots of members. That's what it was related to. We could have asked the town of Stowe city manager to communicate. It wouldn't have changed the dialogue, because what we were looking at was what was the restrictions on the conservation of Basin 4. That was my interpretation. Is that correct?
Yes.
I would interpret it the same way, and maybe you go a little further, that in order for us to have a debate on the issues we wanted to debate on, we were looking for expert and external testimony.
Again, that's
the information we needed to make a decision.
Our behavior leading up to the after the March meeting and into the two meetings that we held was to actually get more information to make an informed decision. Is that correct?
Yes.
Okay. Doc survey at a properly noticed public meeting, the chair raised the question of whether 3 commissioners conducting an on-lake survey would comply with the OLM. The commission did discuss the question on the record and distinguish between policy making and open meeting and enforcement not. It's on the public record. It was discussed in the public. It was discussed during the meeting. I'm not even sure the context of this. We're in the meeting. You can't be violating an open meeting law requirement if in the meeting you're having the dialogue and then later on somebody says you violated the open meeting law by having the dialogue about the open meeting law. It collapses on its face.
In fact, it shows extra attention to how important it is to comply with the open meeting law.
Precisely. It's the exact opposite of what was claimed. All right, Mr. Worf, do you have a disagreement on Exhibit K?
No, it's correct.
Exhibit M, I've talked about this before. When you only have 3 members, by definition, any 2 people talking to each other is a quorum. There's 3 members. There's not 5, there's not 7, there's not 15. So when I send an email saying address your comments to me, it's to avoid the idea that we're going to have serial communications, and it's to avoid having deliberations that appear to be reaching consensus prior to the meeting. So my directive to address comments to me is an attempt to comply to prevent serial deliberation, which is prohibited under Section 18. The complaint of the open meeting law actually inverts the definition, which is protected by design, where if I ask for your comments and you send them to me, and then I send them to Connie or Conroy, Mr. Worf, then it would be serial communication. I'm trying to avoid that. So again, we're bumping into this issue of every communication by definition is a serial. Is a quorum communication. I don't know how to avoid that. We're talking about, research materials that were going to be distributed in the meeting. I don't view that as a violation.
I completely
Mr. Worf,
agree.
Mr. Barstow.
I would agree. I mean, what you're really raising here is the difficulty of being a 3-member commission. And, I've dealt with this one for close to 30 years. You have to be so careful on everything. And as far as we are careful. We're very careful. And if we're ever together, we make sure we don't talk about anything that has to do with the commission. It's just been a real difficult part of being commissioners in a 3-member board. And, over the 30 years or so that I've been doing this, I think we've been very, very careful to go with the letter and spirit of the law.
Yeah, and just my personal opinion on this, since I've been on the commission, the 3 of us bend over backwards to be transparent, inclusive, collaborative, making sure that the people who are around the lake understand what our intent is. There's no private deliberation that goes on for our personal interest. We spend a lot of time, agonizing over any rule or any substantive change to anything that we do in the lake, because every time that you make a decision, somebody could be impacted positively or negatively. I mean, when we changed, like, I'll bring up the snowmobile or the motorcycles, that was a very difficult decision, but as a result of it, the people by and large understood where we were coming from. We don't want motorcycles spinning around here in the middle of the night with no lights on, and people have by and large complied with that. But somebody on the commission has to talk about it. I mean, that's our obligation. So, all right, this is another example. Exhibit L, the open meeting law trap. This is my email. This is the verbatim text. If commission starts discussing the issue with speakers before the comment period closes, it can be interpreted as deliberation outside the proper process. The safe sequence is always read the proposal, public comment, close public comment, deliberate, vote. I'm not even sure how putting the best practice for a Massachusetts public hearing in a message to you two violates the open meeting law. It literally is an instruction on how not to violate the open meeting law. The trap that we're referring to, or I was referring to, is a common mistake that can be made in a meeting where we're unintentionally violating the open meeting law. In order to violate the open meeting law, it must be an intentional violation. What I'm highlighting to you, Mr. Wharf, and to you, Mr. Barstow, is do not fall into a mistake where it looks like there's an intentional violation because we engage in substantive debate with individuals of the public outside of the public meeting or the public comments. It's literally the opposite of the open meeting law. The allegation that we're violating the open meeting law by saying what the open meeting law is I'll be quiet. I don't even know how to address this one. Mr. Barstow?
Yeah, I mean, you were clear that on how we avoid that trap, and clearly stated we don't get into debate during the public comment. Otherwise, the public comment just falls into disorder. You handled that correctly.
Mr. Wharf, do you think me reminding people what the open meeting law is a violation of the meeting law?
Well, no, I'll go so far as to say that we were reminded by both the town clerk that public comments are listen-only effect and really not a good thing to have on agenda except for hearings.
So we have the town telling us what to do. We have the state telling us what to do. We tell each other what to do to make sure that we don't violate the open meeting law, so that we are transparent, that we are inclusive, that we are making deliberations public, and making sure that we reach conclusions that are based upon things that we hear in the deliberation and based upon feedback from the public. How somebody can take that and turn it upside down and call that an intentional violation, again, we have to address it, but it stands the definition on its head. Any other comments?
I agree.
I agree.
Okay, so now we're going to get to, those are the greens. So now I want to go back and look at where we might be able to do better. So we've already talked about this. Deliberation is intentional deliberation with the intent to pre-decide the outcome of a meeting is what the open meeting law seeks to avoid. We've already went through, 10 examples where what we're trying to do is be more transparent. What we're trying to demonstrate is more inclusiveness. All of those demonstrated efforts were then thrown back on us as evidence that we're not inclusive and that we're not transparent and that we pre-deliberate. The next few that we're going to go through show consideration. And I want to make sure that the people who are listening to this call understand this. We take this seriously, and we don't begrudge the people for raising these concerns, and where there are areas that we could potentially do better. But to take things that are intentionally designed by the Lake Boon Commission to achieve transparency, and then to turn it back on us and say that we're deliberating serially to obscure and to predetermine what the rules are, despite all three of us suggesting that the rule was a very hard, change for us. I don't know what to say. We'll address it to the state attorney general's office. So let's go through position E. In my view on this one, so there was a comprehensive position paper, which what it did was it took all of the laws of Massachusetts, Connecticut, Rhode Island, New Hampshire, Maine, and it laid out all of the potential considerations that were given by those states. So it was essentially a research paper, meaning like this is a research to guide and educate the commission, and it was circulated. Mr. Barso, you responded that it looked very good. So my intent was not to have serial deliberation, but was to educate the individuals of the commission of what the other states were doing. It wasn't to predetermine anybody, but it was related to education and research on what other states were doing.
And the research looks very good. I don't understand the problem.
So that, Mr. Worf, what do you say about that?
It's the same thing that Dan said. I mean, a lot of this comes down to the fact that we have to research and distribute information, or we can never deliberate accurately. I mean, you have to share information before a meeting. Sharing information is not deliberation.
Again, I read this as because I didn't want everything to be green. We sent out research on what the law is. So if people believe that sending out communication research on what the law is deliberation, I'm not exactly sure. I guess what we could do in the future is I could send out an email and say, please review and then list all of the laws that you individually could go research, but it seems like inefficient.
I agree. I'm going to go with research. If any one of us finds something on any topic that might be related to the lake, I mean, it's our responsibility to share it with the other members, and then if we want to make an agenda item, make an agenda item, and then talk about it.
Mr. Worf?
That was me.
No, I'm sorry, Mr. Barso.
Yeah, no, I agree.
I don't even, so, I read this one as strict as I could. I have it a yellow. Do you guys have a different view on whether it should be green?
You call it, yeah. I don't think it's a problem. I appreciate the depth that you're giving this, and maybe we can rethink that. To me, this looks fine.
Mr. Worf?
To my knowledge, we've done no actions on this topic anyway.
We didn't do any action, and it gets back to what you said, Mr. Worf. If one of the two of you did research to find out that people were, leaving barrels on the ice and in the winter, and then those barrels sunk to the bottom of the lake, and as a result, it increased the amount of, I don't know, iron or, rusted metal and created a hazard, and you sent me that research, is that a violation of the open public law or open public meeting law? I don't even know.
I don't see how it can be.
Mr. Barso?
Yeah, the issue here is in order to have useful public discussions and our public debate on topics, we need something in hand. We need an agenda. We need something to talk. If we have to have a meeting every time we're developing an agenda, then it just doesn't work. You need the basis on which we're providing a service to provide a research or whatever the base is, so that the public discussion and our public debate over this is meaningful and useful. And to have every step of that process as a public meeting, we're not hiding anything. We're preparing for an effective public meeting.
I just don't know how you can be a responsible member of a commission that comes into a meeting completely oblivious to the world around them. I don't know how that serves the public good. But nonetheless, that's what the Lakemont Dock Committee believes we should do. But if you all are aligned to it, we can change this to green.
I'd say green.
I would say green too.
Okay.
And actually, it's such a good idea. The fact that we have done nothing on that particular issue, we've changed our bylaws. We haven't had an agenda on it. We've done nothing on it yet. So green.
We didn't even deliberate it. We didn't even have a discussion on it. So, I mean, I don't know how you violate an open meeting law and pre-deliberation for a topic you didn't even discuss, but members of the community think differently. Certain members of the community think differently anyway.
Yeah. To my knowledge, all we've done is raise the issue that we should raise the issue.
Yeah, so the next one is we need to post an agenda. Let me talk about what this is so anybody watching understands. We made the decision to post proposed language prior to the meeting. Meaning, like, when we sent out the notice for the public meeting, we included the proposed language, correct?
Correct.
Any idea how you can post an agenda with the recommended language without referencing the language that you're posting? Anybody have a answer to that one?
Nope.
No.
Mr. Barstow, can you publish an agenda without my approval?
No.
And so if you and I get together and approve the agenda, is that under the open meeting law, there's 2 out of 3 of us that it's a quorum, correct?
Right. And I'd like to go back. You made this point early on that development of the agenda and documents like this to be publicly discussed has already been established as a legitimate part of a commission's operation. And we're seeing different instances of the same concern, that the fact that we discussed, that we developed an agenda is somehow subterfuge or hidden. We are required, in order to be effective, to have some agenda and the content of the meeting in order to have an effective public discussion.
Yeah, I can hear your frustration, and you can understand the amount of effort I put into this presentation by looking at it.
Mm-hmm.
So,
yeah.
Again, how would we publish, Mr. Worf, how would we publish a proposed rule if none of us are allowed to look at the proposed rule?
Well, you can't, but I would go a little further. In the context of an open meeting, what we're doing is we're giving definition of what the agenda item is going to be. So, one of the things, again, the town clerks have talked to us about is the agendas need to be a little bit more specific. So when you add, this is what we're going to talk about, i.e. a possible new rule, what we're doing is we're sharing more. We're doing a better agenda so people will know what's going to happen in the meeting.
Precisely. So, Mr. Barstow, we posted suggested language. Is that correct? That wasn't the final language?
That's correct.
If we had predetermined what the language was, why would we post draft language?
You wouldn't.
Common sense. So when we had the meeting and we discussed at March 8th the final language to be included, was it the same language that was posted in the agenda?
No,
we did make some edits, as I recall.
So we posted draft language, we deliberated that language in the open meeting, and we changed the language.
Correct.
So how was it predetermined what the language was if we change the language.
And let's also get at motivation here. The three of us, well, I'll speak for myself. I have no interest in predetermining this. This was, I've been on the commission now, I don't know, 6 years or something. This was without a doubt the most difficult and challenging issue we've had to deal with. We absolutely wanted to get public input. We wanted to get input from our new neighbors in Lakemont community. We wanted to get input from the Conservation Commission, from the Scientific Advisory Board. And we needed this input in order to deal with, should we restrict the docks? Should we restrict powerboats? Should we just let it be? What are the scientific factors? We had to get all this information. That's why we had these meetings. And I think, I want to say to our neighbors that the new people have moved in. Thank you for moving in. We hope you enjoy it. This is why we did this openly, because this is a difficult decision.
The open meeting law complaint suggests intentional subterfuge. Let's just keep going. Okay, and I'm going to test you guys a little bit on this one. PFAS. Was the first time, Mr. Barstow, Mr. Worth, the first time we discussed PFAS, was it in March of 2026, or had we discussed PFAS multiple times?
It has come up before. We've invited our local expert, our scientific advisory board, and Mr. Westfall, who's a real world-class expert in this, to speak on previous occasions.
So, and I'm going to go through this, Mr. Worf. Is PFAS new? Is that a March 2026 aberration?
No, in fact, I don't know if you guys remember, and it might have been before you two were members, but remember that the town wells in Hudson ended up with PFAS contamination, and was never something that was part of our authority, but it was certainly something that we were aware of, and that goes back a lot of years. So we've been worried about PFAS getting into the lake for a very long time.
So is PFAS something that the Lake Boon Commission invented, or if somebody Googles PFAS, could they find out what PFAS is?
No, we didn't invent it.
We didn't invent the idea of PFAS disposal site in Basin 4, did we?
No.
In fact, that was, to me, I knew about PFAS. I knew about the water migration. I understood all the stuff about it, but I did not know that basin had been designated as disposal site. That was new knowledge.
I didn't know that either, but it had been discussed in numerous public meetings. Are the minutes to the public meetings that the Lake Boon Commission holds, are they available to the public?
Yes, they are.
So would a reasonable person investigating the conditions of a lake where they're about to buy property, would a reasonable person do independent investigation?
Yeah, and this has been discussed. I mean, Lake Boon Commission has not been the primary forum. This has been, the towns have been, and the state have been struggling with PFAS issues, trying to understand them, especially with the firefighting academy nearby, for years. This is common knowledge.
So Mr. Worf, was it when you made the comments on the PFAS, was it because you wanted to deny the public access to the discussion on PFAS, or did you want to not have to rehash 10 years of PFAS discussions?
Well,
or whatever. Why did you object to a complete education on PFAS?
I'm not quite sure what you're asking me, but that's a two-part question. Number one, I would not object to discussion on it. But number two, it's really outside our authority unless it affects the lake. And what we learned from our experts was that Basin 4 has a PFAS problem, and I didn't even know about it until we just learned that. I didn't know that it was in the sediment down there. So that's new information, and it absolutely affected how I felt about voting on it.
So I gave myself a yellow because, my initial response was, well, we should have downloaded to some public forum the last 20 years of meetings to allow the people in Lakemont to do research. But now that I look at it in black and white, I don't see this as a violation.
I
I
agree.
didn't either.
And in fact, we explicitly made sure that we covered the PFAS topic there and had an expert and, the latest data on this.
I mean, what you're getting at a little bit here is, you know, and I don't want to throw anybody into the bus or anything, but people have a responsibility when they're acquiring property to do a little bit of research. And if they didn't know about the PFAS, it was public knowledge. Everybody knew about it. The only thing we didn't know was the fact that they designated that basin as that part of that basin rather as a disposal site. That was new knowledge. But the fact that it was here, the fact that it was being investigated, the fact that we've had well issues, all the migration through the ground, that's all public data.
And I think that where you say, and this is my reading of your email, may generate lots of questions about PFAS into focus the meeting. I think the way I read that is this isn't a PFAS meeting. It's a meeting that the experts are going to testify on it, but we're not going to go through the history of PFAS.
Correct.
Okay. And I'm changing my vote on that one to green. Mr. Marshall, Mr. Warren.
Yep.
The only relevance that PFAS has is the new data that we learned about its presence in Basin 4 sediment. We didn't know that.
Yeah.
I didn't know that.
Well, it's interesting because your email suggests that you learned it for the first time in the meeting itself.
I did.
So where it says PFAS has no relation to anything in Basin 4 contradicts what happens in the meeting, which you indicated earlier was when you changed your mind.
Correct.
This is the complete opposite of the open meeting law violation.
Correct.
Okay. Yeah. Now remember, going back to the open meeting law, it's intentional violation. Acted with the intent to violate the law, acted with deliberate ignorance of the law requirements, or was previously informed by a court or the attorney general that such conduct would violate the open meeting law. So far, I've been through you guys with 30 pages. Is there any indication that we showed the intent to violate the law?
No.
Absolutely not. Our whole goal here was to have a public debate to enable us as commissioners to publicly struggle with the issues here, to enable the public to speak, to have the scientists speak, to have the experts. These are issues that have been in the public for years. The Hudson Conservation Commission, the Hudson Review of the Property, all dealt with these issues beforehand publicly. And we wanted yet one more opportunity to really have public input on this. We needed that in order to be able to honestly and difficultly struggle with coming to our decision on what is something that clearly impacts on people. We're sensitive to that, as you said at the beginning, Mr. Turow. This is a difficult issue, and it has impact on our neighbors who live there. We welcome them, but this is a serious. I'm not getting into the substance of the reason for the decision, but the reason for the public meeting and why we carried through on all this, having these two meetings, inviting the experts, making sure people could speak, because that we needed this input. That's exactly why we did this.
Mr. Worf, anything to add?
Yes. In some ways, this particular one is almost personally offensive. I've been a commissioner for close to 30 years, and for 30 years we've done everything we could to, comply with open meeting law. So the intent has been to bend over backwards to comply with the law. There's been no intent to try to evade the law.
We just went through 13 specific complaints, 13 or whatever, 12 to 13 specific allegations that we intentionally violated the open meeting law with the idea of subverting a decision on Lake Boon. And most of them related to just preparing for an open meeting itself.
I agree with that.
Yes, I agree.
Okay, let's keep going because we're not done. Well, my computer froze. Maybe we are done. All right. So what is intentionally circumventing the open meeting law look like? Canceling a publicly noticed meeting after it was announced. Did we do that?
No,
No,
Avoid placing Rule 7B on a posted, they keep saying 7C, but on a posted public agenda.
no,
Did we do that?
no,
no.
Did we vote outside the meeting?
Nope.
I'm sorry, I'm laughing at that one. Of course we did not vote outside the meeting.
Did we, the most aggressive, assertive community related to this? By the way, I don't begrudge them. They paid for expensive property. So I don't want anybody to mistake what I'm saying. I understand I would be upset if I bought a property I didn't fully understand. But did we exclude the Lakemont, anybody, forget Lakemont, did we exclude anybody, especially the complainant, from speaking at the meeting?
no,
Actually not, and that's the evidence of that is the fact that we extended the meeting to a second meeting.
And we accommodated,
second meeting.
we accommodated the complainant by letting him speak as long as he wanted to.
That's correct.
Did we adopt the rule that in the very first meeting without changing it?
No,
no,
Did we refuse to consider any alternative views or expert testimony?
absolutely not.
nope,
Okay, so in every case where a serious violation of the open meeting law occurred, at least 2 or 3 of these happened. Not a single one of them happened in Lake Boone Commission. Do we agree,
yes, we agree.
Mr.
Yeah.
Worf?
Yes, correct.
Okay, so by every measure, we did it. So the notice on the second meeting and maybe even on the first, was it more than 48 hours, Mr. Barstow?
Yes,
Yeah,
Did we make the minutes available and post them?
yes, and
Did
the video recordings.
And the video recordings were available? Did we hold a secret meeting or did we invite people to speak?
No,
we certainly didn't have any secret meetings. If we did, I didn't know about it.
Deliberation. Did we deliberate?
we sure did.
During the open meeting, we deliberated. That was the only time.
Okay. All right. So one thing I want to make in dealing with this, and this is why I'm being so complete, that I don't feel like this issue is going to go away. We have agitated homeowners that are upset with the Lake Boone Commission because they can't convert public property into private space. So let's go here. When I read the complaint, it doesn't look to me like the complainant actually looked at the diligence, meaning like did not investigate work that had been done by the towns, work that had been done by the LBA or the LBC or the Scientific Advisory Board. 6 years of meetings were available, including video, including all of the minutes from the last year leading up to the discussion about PFAS. So had somebody done diligence, they would have recognized that the issue with Basin 4 was existing. We put a buoy in Basin 4, correct? Because of the safety concern.
We put a caution buoy down there. Yes, absolutely.
So there was, other than pleading with us for sympathy on the fact that they bought a home, there was no substantive engagement on the merits of our deliberation in the meeting. Meaning, like, from what I heard, and we addressed this in the original, meeting, there was no rebuttal to our experts or to the towns. That was my, unless I'm wrong.
Well, no, I mean, clearly there were different points of view expressed about whether maybe the issue is really the power boats rather than the docks, or maybe a dock is a better way than having people, stepping into the water and the way, the shoreline where it can be dangerous. I mean, those are all things that we heard and we had to weigh in our thinking.
Mr. Worf.
Yeah, I guess I'll make a comment, but my comment is that I feel sorry for those people because, you bought an expensive piece of property in what you thought was a pristine lake, And what you find out after the fact is that you really bought property. I hate to say it, but everybody that's been on the lake for years, we all call that the stumps in the swamp. Because we know it's all mud down there. We know it's all stumps everywhere. We know it's not a good open part of the lake. So I feel sorry for the fact that maybe they didn't realize that before they bought the houses.
Although it's part of the restrictive covenant.
Well, the covenants. If you look at the covenants, you look at state law. I mean, we're the last people you got to convince to do something. Um, so I feel sorry for the people that want docks, and you know, everybody involved in that development of that property knew that the original plan said no docks. We didn't do that. The Conservation Commission did that, and they enforced that by saying you have the 30-foot no disturb and no structures clause. A dock is clearly a structure. You have a covenant on your deed that says you can't have a structure. So I don't know. I feel sorry for them, but at the same time, it's in the covenant, it's in the deed.
So did we, in the meeting, did we agree Basin 4 is different?
Yes.
Yeah.
So we didn't single out Lakemont. This was not a Lakemont community targeted effort.
No.
way.
It was.
No, this is clearly established from the initial research done with the state-funded grant.
Mr. Wharf, do you agree that the Basin 4 and Lake Boon is different than the other basins?
We've always treated it differently.
Okay. So nobody who accuses us of singling out Lakemont homeowners could make the argument that Basin 4 is like Basin 1.
No.
Yeah. So every concern that has been raised, these are the people over the last 6 years that have presented to the Lake Boone Commission or been involved with the Lake Boone Commission describing the health and safety of the lake. Mr. Barstow, Mr. Wharf, you've been here. Is there any that you don't recognize? All of them show up in the minutes.
The only comment I
Yes.
would make here is your title says regulatory bodies. These are not all regulatory.
Yeah, I'll change that. I'll change that. That's a
The
good.
WA Association is not a regulatory body. The health
I'll change that.
Yeah, good
It's a
point.
So Mr. Barstow, let's change that.
I'll leave the editing of this document in your hands, Mr. Thoreau. Is that correct?
Yep. I just want to make sure that
I agree. I agree with that correction.
Okay, so once again, if we were having deliberate, intentional, secret meetings, somebody could have went back and looked at the minutes and saw that this has been an ongoing issue. Yes.
This has been an ongoing issue. You have to look at multiple committees' ongoing records because we all have a piece of the puzzle.
I'll change this regulatory bodies again.
Yeah.
So 6 years of continuous discussion about Basin 4, correct?
Yes.
At least.
Okay. So more than 50 meetings discussed it. We got a grant, 3 years of a DEP funded study, 9 bodies, and we can change that regulatory to non-investigative into investigation bodies, 12 different scientists, and a 50-foot recorded buffer, and then 30, feet, I guess,
50-foot non-disturbed, 50-foot buffer.
Yep. Is there anything other than I got to change regulatory? Is there anything here that a diligent buyer would not have been able to find?
No, and this I've been on this commission for a long time, and many, many years ago, we dealt with this whole issue of weeds on the lake, and we went through all this stuff back then. So this has been an ongoing issue for a very, very long time with, what happens down there, the weeds, how do they spread, et cetera, et cetera, et cetera. There's nothing new here. This is what stuff we've been doing for years.
Mr. Barstow, I took the minutes that you sent
Yep.
and I downloaded them and read them.
Yep.
This is a reflection of those minutes.
Yeah, I'm scanning it now. Those all look correct.
I don't know what to say on this. These are facts.
Yeah, and if you were to dig deeper, you'd find even further back there were, like I said, when we did the original drawdown studies and we did the original invasive weed studies, they go back even further.
Speakers who have been engaged in this process, scientific advisory, water quality coordinators, volunteers, Mr. Sawerski, Miss Elstein, Miss Goring have all been involved, correct?
Yes,
It wasn't just the three of us.
it absolutely included the others. We needed them in order to have a true understanding and make this difficult decision.
Yeah, I would go further and say we were looking for public support of what we had to do or what should be done is a better way to say it. And so yes, we had to we got it from all these people.
Okay, so here's just more of the restrictions recorded on every Lakemont. I mean, this is public knowledge. We're one of many interested parties in not letting Basin 4 get overdeveloped. In addition, as we indicated in the last meeting, when you clear cut dozens of acres and hundreds of trees, you have no idea what the environmental impact is going to be on the lake because you don't know what the erosion and environmental runoff is going to be. So even to make a rule and then allow docks to be put in without understanding that first would be negligent. I mean, we're not saying it's never going to be reversed. There's a period of time at which the lake has to settle, but for now, the restrictions on every recorded Lakemont lot already prevent docks. To your point, Mr. Wharf.
So yeah.
Okay. The risk to Basin 4 was not new. Streamlining the hearing through agenda and communication of research is not evasion, and volunteers like us, because we're not paid to be on the commission. This is a volunteer organization, and so we've done this because we love the lake. We don't begrudge other people for challenging our decisions, but some of the allegations, quite frankly, seem personal. So I would ask that the people who supported the ban of docks, understand that we're looking out for them, and I would ask that the people in Basin 4 who want docks to understand that we're trying to do what's right for the lake.
Yeah, go back to that slide, please. Right there, number 3. I would prefer that we soften the end of that sentence because yes, they should have done. Maybe the prospective buyer should have done more work, but that's a true statement. But I don't think it deserves should be in this presentation.
All right, I'll take it off.
It's absolutely true, but it's not up to us to tell
Yeah.
them what they should have done.
No, your point's well taken. This is not a personal thing. This is just we have to. I take this as an opportunity for us to understand as well as we can the open meeting law and how we comply with it and make sure that we do. And so this has has that value. And I'm willing to remove statement 3.
Yep.
Yeah.
It's
You
gone.
take the whole statement out.
Yeah, I might take the whole thing out because it's
That'd be
you
better
always get
because
to the conclusion anyway.
Yeah.
I would take the whole statement out because
Yeah.
That is statement 3, right? You leave 1 and 2.
Yeah.
one
Yep.
and two
Yeah.
are good.
Yep.
All right, let's keep going.
Go ahead. Yeah.
No, I understand, Mr. Worf. I'll take it out. Again, this was my opinion, and I expected and was hoping that you'd push back.
Yep.
Okay, so the open meeting law is forward-looking, so I want to make sure that everybody understands this. In state of Massachusetts in 2025, according to the data that's available publicly, there were 306 complaints that were filed with the state of Massachusetts. 56% found some form of violation. A lot of times it has to do with meeting minutes, scheduling, meetings too late, not publishing the minutes afterwards, et cetera, et cetera, et cetera. They don't void the restriction, or they don't void typically the enactment of the rule. They essentially just ask you to redo it if there's a violation. In total, Massachusetts issued $1,350 in fines. So for those people believing that they could, use the open meeting law to get docs, that's not actually how it works. As I mentioned at the outset of this meeting, there's no legal right to have a doc, period. It's a privilege. It's not a right. And since the people who don't have docs today aren't entitled to have docs, there's no right that's been violated. So even when the procedure is imperfect, there's no protected right to restore. A lot of times when the open meeting law is violated, it's somebody loses a right. Somebody was denied a right. Because docs are not a bestowed right on a property owner, especially one with restrictive covenants, the only thing that would likely be required is, a redo of the meeting. So let's keep going. So none of the remedies that are being sought by the complaint are remedies that are going to address what the individuals want, which are docs. None of that is going to happen without a lawsuit, and we would not be the recipient of the lawsuit because we don't register docs. Docs are licensed by Rule 91, and they're licensed by the town. So
Chapter 91.
Chapter 91, right? I'm sorry, Chapter 91, and the restrictive covenants in the town of Hudson, in the town of Stowe. So we would be immune from. There would be no standing to bring the Lake Boon Commission to any sort of litigation because we don't license docs. We prohibit docs, but we don't license them. So you'd have to go through 3 denials essentially. The other thing, it's been proposed that there's a safety concern about mud and people slipping on mud. For the same reason that we don't install handrails during the winter so that people can walk around the ice without falling, we don't subsidize people to rebuild slippery rocks or foundations around the lake. The Lake Boon Commission has no responsibility for ensuring obvious risk of living on a lake are protected. So I can't even begin to imagine what the state might look like if somehow or another the Lake Boon Commission had to child-proof the lake, or not. I don't mean that in any sort of derogatory way. I mean, that's not the function of the Lake Boon Commission. It's not the function of our commission to remove known safety hazards. So I feel that some of the requests of us are beyond what the scope of our actual authority is.
I would agree with that. It's a lake. It's a water body. Water bodies are hazardous to get in and out of, period.
So,
Go ahead.
no, you go ahead.
No, go ahead.
So I'm responding to this with 2 parts of my brain. One part is, what about the open meeting law? Do we fully understand it? Did we fully comply? And all of that seems to be yes, yes, yes. From everything that you've articulated, what we've gone through, this is unequivocal. We've complied with both the intent and the practice. The other part of my brain is the scientific and substantive decision that we made. And it's unfortunate that the open meeting law complaint appears to be a way to overturn a decision we made based on scientific merit.
Yep.
And what you're saying is that those are 2 independent things. So
Correct.
I react to this by saying, okay, we have correctly responded to the complaint. We respond, okay, end of story. I hope it's the end of story here, because this is, in any case, not the way to have a rethinking of the underlying science. We had that
Correct.
opportunity. That's a separate topic.
Correct. So let's go through what we've learned. I mean, I do believe that and I'll restate what I stated at the outset of the meeting. Look, anybody has a right to challenge how we make decisions. That is a fundamental right. And if we did something that violated a rule or a law or even the intent of a law, I'd be the first to raise my hand and say that, we can do better. So I think one of the things that we need to do as a commission, and one of the things that we need to tell the Attorney General is like, look, we're going to be more careful. I mean, that's ultimately what, the Attorney General's office is looking for is, did you guys learn anything from this? Is there anything that you would do better? Yeah. I mean, again, getting down to every single communication is now a quorum because there's 3 of us. I'll highlight that. But, one of the things that I'll mention is that, we'll volunteer to go through the refresher of the open meeting law, and we'll make sure that we do a better job of documenting things and keeping things simple. As we learned, people are going to now access every email that we send to each other because they're looking for a way to overturn a rule they don't like. Unfortunately, that's not one of the remedies, but I do have to communicate to the Attorney General's office what we plan on doing. Does anybody have any disagreement to the 5 things I have here?
None.
No, they're all well stated.
Okay. So now, Mr. Barstow, in anticipation of you asking that question, and you have not seen this, let's discuss Lakemont community. If the people in Lakemont community believe that they have a meritorious, not a you violated a procedure, but if you actually have a merit-based dialogue and you want to challenge it, propose that challenge, and here's what we're going to do. There's 30 potential affected properties, and it was not adopted in response to the request for 1 or 2 docks. We identified 21 properties and up to 30 properties affected potentially by the prohibition. So as we've said, I think maybe 100 times in the last 3 meetings, no one on this Lake Boon Commission sought to deny docks. We had to look at all of the factors. So there was no contesting the potential impact or the number of properties that were impacted, meaning like if there were going to be 11 or 12 or 15 or 20 docks, no one from Lakemont came back and said it only affects 4 properties. It only affects 5 properties. Here are the 5 properties. That was never offered up. And because it was never offered up, there's nothing we can do. We have to take the facts as they lay. And our obligation isn't to those 30 properties. It's to the more than 200 people that live on Lake Boon. So for everybody who was disappointed with the rule, there were 3 people that were, happy with the rule.
So I want to go back one, please. The commission's regulatory duty is not just to the lake residents. It's to all the residents of Hudson itself.
Yeah.
I mean, our responsibility is not just to the residents, because the lake is a great pond in the state of Massachusetts. We have a public launch on it. We have a responsibility to take care of the lake for everybody.
Yeah, and that's a good point. I'll clarify that. I tried to clarify that in the meeting, but I'll clarify on this.
I agree.
And these, by the way, these slides are not going to the committee. Although they might if I change them, but it's going to be a write-up.
Okay.
So, Mr. Barstow, during the meeting, you put up a map that showed 11 potential new docks.
Yes.
Did anybody from Lakemont say it was only 2 or 3 docks?
No.
No.
So we have to take 11 docks as being 11 docks. I mean, there was no rebutting of that. Nobody from Lakemont said it's only 1 dock, it's only 2 docks. So we can't now say, well, it's not 11 docks. We had an open meeting. We had allowed the public to speak. The Lakemont community had a representative that spoke on their behalf and did not challenge 11 new docks. 11 new docks in 3 feet of water in that proximity, the idea that that would have no environmental impact and no safety impact is questionable. We talked about this. So just on 11 docks, 11 more vessels in 3 feet of water, holes and props in inches of sediment, and public trust that was granted to us to manage the Great Pond, There was no rebuttal to that proposition at all. It's illogical to think that you could put 11 boats in close proximity moving in and out of that water without stirring up sediment, without increasing safety risk. It's just not anything that was, contradicted from the people that testified that we needed to protect Basin 4 differently. Am I reading that wrong?
The number one, the number one risk that we're trying to mitigate is spreading of stuff from Basin 4 into the rest of the lake. So yeah, stirring up that sediment, especially the contaminated sediment, is not something we want to have happen.
So, Mr. Terrell, I'd just like to be clear here that the points you're making here on the scientific merit are valid points. I think we need to differentiate the response that is directly to the open meeting law and a response to the substance of our decision. And
Well, that's
do you
true.
understand my point?
That's true, except for if you read the open meeting law complaint, they say that they're trying to attack and rescind the open meeting law complaint complains of two things. It complains that we violated the Open Meeting Law Act, which we did not do. We've already determined that. And then on top of it, they say that we were illogical in making the decision anyway. And they point to that, oh, well, it was overly officious, that it doesn't create any, real disturbance or anything. Yet their entire argument was not made in the open meeting. So they say we violated the open meeting, and then in the open meeting, they didn't make any arguments that they later made in the complaint about the open meeting. So my point is that we had a meeting, we had people testify, including Lakemont community. They didn't like the result, and so they went back and then challenged the merits of the decision in addition to the the alleged violation of open meeting law. So my point here is you can't have an open meeting law and then later think of new arguments and then go to the state and say, I thought of some new arguments. That was my point.
Okay.
So again, if the Lakemont community, which is the source of the discontent, if they would like to reconsider or have us, then they could have bought an environmental impact expert who's an expert in PFAS and sediment, water particulates, and aquatic, disturbance modeling in shallow water. They could have bought an engineering feasibility expert to talk. They could have brought in a safety expert. They could have brought in a Massachusetts environmental law and regulatory compliance individual. Our responsibility is not to arm, an individual committee that wants to overturn a policy decision without rebutting on its merits how we made that decision.
So,
Right now, it's a matter of opinion.
May I comment, Mr.
Sure.
Giroux? So I believe we're addressing the open meeting law violation complaint, not the context or containment of what our decision was on that meeting. These two slides, these two things are directly a talk about the decision to ban docks in Basin 4, which is not what the complaint really is.
No, the complaint in there asked to overturn it on the merits.
Yeah,
Okay.
I think Mr. Worf and I are, expressed the same question here, and I would say I agree with your response, Mr. Terrell, that because the complaint actually addressed questions of substance of the scientific merit, then we have an obligation here to respond to that aspect. I want to make sure that we're not in this part of the meeting sort of re-deliberating a decision, that we're responding to the complaint.
Well, what we're responding, and this is good feedback, but what we're responding to is in the four corners of the complaint itself, it goes beyond an open meeting law complaint.
Mm-hmm.
Okay.
It goes to, it says, in the complaint, it says, they want it overturned because of alleged violations of open meeting law, and they want it overturned for the merits. So what I'm suggesting here is when we go back to the state, that if the state says you need to have another meeting, we're going to have the exact same conclusion unless the people who are against the regular, the new rule come prepared to match,
So, Mr.
these
Crowe,
elements. And that, I mean, actually it's more of an invitation of, if it gets kicked back down to us, it gives them a heads up of what it would take to overcome it.
yeah, no, a simple way to say that is we made a decision based on the data we had. It would require new data to change that decision.
Exactly right. That's exactly right. That's exactly what I'm saying. So when we go back to the state, we'll say if this was predetermined, if this was intentional deception and all the things that we were accused of, then we would shut this down. If somebody can convince us that there's zero risk in 11 docks in that confined area in a PFAS disposal zone, I'm sure. I mean, I'll hear it. Doesn't mean we'll change the rule, but I would hear that. I'd hear the argument. I mean, if that's what they want, I'll hear the argument, but it's going to have to be an expert willing to testify that boats themselves in 3 feet of water don't churn sediment. If they can find one from the Massachusetts Environmental Law Group and Regulatory Compliance Group, I'm not going to say no.
Let's move on.
Okay. But that's just more of what we said. They had the people that were complaining had an opportunity to present the case. They didn't. All right. Two publicly, let's bring it home. 2 meetings were publicly noted. We had no violation. We had 5 speakers invited to testify. 35 people attended. 100% of our emails were produced. We've now reviewed them twice. Unanimous vote, and 2 towns with agendas properly posted, plus the LBA. Record's open. It's complete. As far as I'm concerned, we're vindicated. But again, tell me if you guys disagree.
I agree.
I agree.
Doesn't mean it won't stop, but I agree.
Okay. So anyway, I'm going to keep going. So let's wrap it up. I'm not going to go any further. I would just like to say on the record that for those of you who are reaching out to me directly through email and through text and through other social media, please stop. Please direct your comments, questions, concerns through the towns. We understand that this is an emotional decision. We understand that people are not happy with it, but we made the decision and we're standing by it as of today. These are all the meeting minutes that people can go back and access if they think that anything in this record is incomplete. Mr. Barstow has all the minutes. All the towns have the minutes. If anybody's interested, they can go back and look at the minutes.
Dan, could you go back 1 slide? You said at the edge of a former swamp. So I've been on the lake a lot longer than most of you guys have. And when I first came to the lake, that was nothing but a swamp. It was infested with weeds. You couldn't even go down there in a canoe. It was so overgrown. We made a decision a long time ago that we would treat the weeds in the lake and try to open the water up, and we did that. So we don't have the degree of growth down there that we used to have, but still, come this August, it's going to be very thick down there with native weeds. The pond lilies and all the other weeds will fill in, and that basement will be almost covered shore to shore with weeds. So the idea that it's a former swamp is not true. It's still a swamp. It's only 3 feet deep in most places. There's all sorts of stuff in there, and if we did not treat the lake with the herbicides that we use, that place would really be overgrown.
Yeah, I'm gonna take this out. It was just what I said verbally is going to go in the report to the Attorney General's office. I think we're bumping up against harassment.
Yeah, I think it's unfortunate that we've been harassed, and you especially, Mr. Turow. But I think that page is not relevant to the response.
Yeah, I am gonna note to the Attorney General's office that we're making a request of just on notice that we've been receiving unwanted communication. Let me just leave it like that. Okay? Those are the records. If anybody wants, I'm going to make sure that when we respond that we didn't come up with these laws on ourselves. We didn't make these up ourselves. There's plenty of case study in the appeals court and the Supreme Court of Massachusetts addressing all of this. The statutes and regulations are very clear in Massachusetts if anybody wants to research them. Again, we looked at New Hampshire, Maine, and other authorities in making the decision. That's it. So thank you. I know it was way more than what you anticipated, but I feel, oh wow, that's pretty dark. I believe it was necessary because I don't feel like this is going to go away.
So question, can that presentation you just did will be part of our minutes? Yes?
What will?
The presentation that he just did
Yes.
will be part of our minutes.
Is that
Yeah,
correct?
it's a draft presentation.
Yeah,
Could that presentation,
as edited.
as edited, be distributed to the members of the commission and then included in the minutes of the meeting?
Yeah, I think first we need to I move that we authorize Mr. Giroux to integrate the edits that were discussed during this meeting, to prepare this as a final report, to submit it to the relevant authorities and including to us, and then we post it as part of the public records of this meeting.
I would second that.
All in favor?
Aye.
Aye.
Aye. So I will work on the response, and I will also edit this deck based on your comments. So, as I mentioned at the outset of the meeting, Mr. Barstow, this is a draft. So, the final version will be different.
Very well done, Mr. Terrell.
All right. Any other comments? Mr. Barstow, anything else on the agenda?
No, only to adjourn. I
Okay.
move that we adjourn.
Motion to adjourn. All in favor?
Aye.
Aye. Have a good night.
Okay, bye.
Bye.